My name is Laura Wilson, Firm Administrator at Wilson Law Group. This is the second chapter in Trustee Orientation 101, the Trust Process, entitled Tax-Centered Planning and Your Family. The presenter of this program is Attorney Daniel Pertel, Principal at Wilson Law Group. Attorney Pertel is an estate planning law specialist and accredited estate planner, certified by the National Association of Estate Planners and Counsels, and accredited by the American Bar Association. In this chapter, he will introduce you to the planning pyramid and the impact of the upside-down planning pyramid, a more in-depth view of the probate process, and the reason why tax planning alone is simply not enough. Discussion will include how you can address not only the distribution of your assets after death, but also how you can plan for unexpected lifetime events. Remember to take note of any question you may have along the way. Let's begin.
So if you look at the estate planning pyramid on this slide, the most important level of the planning, the foundational level, is you, the person that created the plan. It is the husband and wife, it is the individual. When we sit down with our clients, we want to know about them. We want to know what their aspirations are, their goals, their family. That's the second level. What issues are there with the children? Do we have any children with special needs or special circumstances? Do we want to go to the grandchildren with distributions? Ultimately, the next level is making sure that we preserve wealth. That could be looking at how we can protect assets from the cost of nursing home and long-term care, and making sure the clients have adequate protections in place that we would discuss with their insurance or financial advisors. That again leads into growing wealth. We do not do financial planning at Wilson Law Group, but we want to make sure that the clients are working with a financial advisor or receiving good and sound financial advice. That is something we always talk about. Finally, look at taxes. Taxes are at the very top, not the top of the food chain, but the very top of the pyramid. That is the last thing that we would put in place. Tax planning is easy. Tax planning is something that we find can be done without a lot of counseling because it is a part of a one-size-fits-all plan. The foundation first has to be family, the clients, and moving up from there. Let's look at an upside-down estate plan. We often see this with law firms that are focusing on estate taxes and other types of tax issues. This doesn't bode well for a good estate plan because, particularly in today's world, the issue of estate taxation has become less important. What is important is passing on assets in a way that is going to protect the assets themselves and also the values of the family that helped grow those assets over time. As we just mentioned, taxes are only part of the overall problem. What else needs to be discussed? Making sure we have disability planning in place, not just appointing people to make decisions, but giving them the tools and information so they can make good decisions. Having definite directives so people who are going to have to make decisions know what we want and we are comfortable passing that power on to them if that were to occur. We are becoming more and more cognizant of long-term care and nursing home care. Having the discussion of how we're going to pay for that, the type of care the clients want to have, and do they want to be at home as long as possible before looking at assisted living. That is all customized planning based on counseling. Probate avoidance is something we will talk about and how to accomplish that. Also, we do have several issues that have come up as it relates to small business, family-owned businesses, and family farm succession for clients that have that component of their estate planning, which is business succession planning. That needs to be done very specifically and carefully in a plan that's customized. So here is another important conclusion. Tax-centered planning, if we are not looking at the overall needs of the family, does not work. So here's a quick quiz you can take. True or false? Estates can be arranged so that no court is involved at time of death? Is that true or false? Think about it for a moment. The answer is true, and we are going to focus some of our time talking about how that can occur. Let's start off with some traditional ways of avoiding court involvement or probate. The first way is to create non-probate assets with joint tenancy. I mentioned earlier the example of husband and wife owning property jointly. If husband and wife own property jointly, when the first spouse passes away, there is no need for a will or probate because everything simply passes from husband, if husband dies first, to wife as the survivor because things are titled in joint tenancy. Joint tenancy essentially means last person standing. What we are concerned about, though, is the use of joint tenancy as a global way to avoid probate. What can occur if dad passes away? Mom receives everything because it is owned jointly. Mom looks at it and says, well, that seems like a pretty good idea. We can avoid probate. Assets can pass without court involvement by simply having joint tenants named. So what does Mom do? She goes out and she names the 3 children as current joint tenants on all of her assets, real estate, bank accounts, investment accounts, etc. Will that avoid probate on those assets? The answer is yes, of course. She will avoid probate. When Mom passes, the last people standing are her children, and they would receive equal shares of those assets. Here is the problem. What if Mom had a situation where she wanted to sell the house? Is she the sole owner? Not if the children are named as joint tenants. She would need to get their permission to sell the house. What happens if one of the children ends up in a car accident and causes some liability? What does that child own? They own a portion of that house. Now the creditors can take Mom's assets away. What if one of the other children ends up in a divorce court and assets are being divided? What does that child own? A portion of that house which is now subject to a divorce proceeding. The intent was good with joint tenancy to avoid probate, but Mom lost control of her assets. There is another issue that comes into play if Mom has property that has been owned for a period of time. Let's say she bought some stock after her husband passed away and she paid $100,000 for it. That is Mom's cost basis in that property. What if Mom then sells the stock for $200,000? She would have to pay capital gains tax on $100,000 of gain. One of the benefits of having assets pass through probate or by the estate plan, not by joint tenancy, is that when children receive it at time of Mom's death, those assets will get a step up in cost basis. Each of the 3 children would have a step up in basis, and if they all agreed to sell the stock, there would be no capital gains because the tax basis would have stepped up to current market value. If Mom brings those children on as joint tenants, they each not only receive a quarter interest in the stock, but they receive her low cost basis. What that means is that when Mom passes away, only her 1/4 will step up in cost basis. Then, if the children decide to sell the stock, there is a very good likelihood that there will be capital gains incurred that could have otherwise been avoided by not putting children on the title during Mom's lifetime. Again, that is a lot of explanation of the pitfalls of joint tenancy, but it is important that we are aware that although joint tenancy does avoid probate, it can cause a lot of problems. Let's move on to payable on death and beneficiary designations. These are designations made with the company that holds the asset to direct those assets to named beneficiaries. For payable on death, you might also hear transfer on death. That is a contract with the bank or the investment company that says, I, the account holder upon my death, want the assets distributed, in this case, let's say, to my 3 children. Beneficiary designations involve assets like life insurance, retirement accounts, and annuities. Much like payable on death designations, beneficiary designations are a contract with the company that says upon death where the value of those IRA, annuity, and life insurance assets go. They go directly to the named beneficiaries, and yes, they avoid probate. If we are looking to avoid probate, that is good. But let's talk about some problems with direct nominations through PODs and beneficiary designations. Let's take the common situation, husband and wife. Husband has $500,000 in life insurance, as does wife. Husband has wife as his primary beneficiary and his 3 children as the contingent beneficiaries. Wife has husband primary and the 3 children as her contingents. Husband passes away. Does that life insurance money have to go through probate? The answer is no. It goes directly to wife, and when wife receives that money, she can do with it as she pleases, which is of course what husband wanted to have happen. Let's say wife puts that money into a joint account with a new spouse. Then Mom passes away. As the surviving joint tenant, the new spouse would receive all of those life insurance proceeds. It is not too much to expect that the first husband would have wanted that money eventually to go down to his children or their joint children. Instead, it went to a new spouse. We have seen those things happen, and it causes problems. Let's take it to a new level. Let's say mom and dad both die in a car accident coming home from dinner. The children are all minors in this scenario. We have a 5-year-old, a 7-year-old, and a 9-year-old. Mom and dad simply have named the kids as the contingent beneficiaries. Can minors inherit money? The answer is no. What would happen to that life insurance money? It would have to go through probate, and the probate court would establish trusts for the benefit of each of those children. Each child would receive in trust 1/3 of the life insurance proceeds. It doesn't sound so bad because certainly we don't want to have minors inheriting money, but number one, we have opened up a probate estate. The trustee has ongoing obligations to report back to court as to whom and how the money is received out of that trust for the benefit of the child. When does the child take control of that money? Unfortunately, they take control of it at age 18. If you talk to most parents and the question is posed as to what they think would happen if a child is 18 and receives a large inheritance, the answer is inevitably that the money is going to go away very quickly. I can give you a statistic. The average time it takes an 18 to 24-year-old to spend all of their inheritance is about 11 months on average. That is not good. That means that assets are wasted. That means that addictions come, and a lot of friends come and go. And when the money is gone, everyone walks away. It avoids probate, yes, but a lot of issues are there. Finally, gifting does avoid probate. Gifting only works to avoid probate if we literally gift away our last penny the moment we pass away. We hear people say it all the time. Well, I'm just going to give everything away to my kids before I die, therefore nothing will be left to go through probate. That never happens. People always have something left. It is very uncommon to see something like that happen. If I gift everything to the kids now, they don't get a step up in cost basis. The assets are not protected for their benefit. If my children are minors, it doesn't work to do it that way. Gifting is just a big problem. Also, it relates to qualification for Medicaid. If mom and dad need to go to the nursing home and would like to qualify for Medicaid to help pay for their care, there's a 5-year look back right now. If you make a gift within 5 years prior to needing care, you will have to disclose that. It very well may mean that you will not be able to receive Medicaid assistance to cover the cost of care for a period of time because you should have had that money to pay for your care. The conclusion here is that we see a lot of ways of avoiding probate, but they oftentimes have a lot of problems. Our proposal, and the proposal our clients accept as they come into this type of planning, is the use of a revocable living trust, or what we call a living trust. That is why you are listening to this presentation. You are either a client that did trust planning, or you are the trustee of a living trust as a successor trustee.
This ends the second chapter in Trustee Orientation 101, the trust process. If you have any questions about the information covered in this chapter, please contact the trust maker, your attorney, or call or email our office. Attorney Pertel will continue this discussion of the trust process in the third chapter entitled The Living Trust. Thank you for listening.